There were only 2 filings over the past 2 weeks, but there was a lot to content. June 9th, state's response to second motion to dismiss, 8 pages, filed by prosecution. My summary is, the prosecution objects to the defendant's second motion to dismiss based upon newly discovered, destroyed, and/or missing exculpatory or potentially useful evidence, and asks Gull to deny because there is no basis in the law or fact to support it. There is no exculpatory evidence and/or potentially useful evidence the state has not turned over or is missing or destroyed. The Odinist BH is not a third-party suspect, and there is no evidence tying him to the murders. 1. Dismissal of charges due to the state destroying or losing evidence is only permitted when evidence is materially exculpatory or potentially useful to the defense, and the destruction was done in bad faith. 2. The defense have not alleged any example of missing or lost evidence that is materially exculpatory or potentially useful to the case against Richard Allen, nor has the defense cited any example of the state acting in bad faith in destroying potential useful evidence. 3. Exculpatory evidence tends to establish a defendant's innocence and clears or tends to clear the defendant from alleged fault or guilt. For the destruction of materially exculpatory evidence to support a dismissal, the evidence must possess an exculpatory value that was apparent before the evidence was destroyed and must be of such a nature that the defendant would be unable to obtain comparable evidence by other reasonably available means. 4. For evidence to be potentially useful, it could have been subjected to tests, the results of which might have exonerated the defendant. To be subject to a dismissal, law enforcement must have destroyed it in bad faith because of a dishonest purpose or moral obliquity. 5. The defense identified 3 items of evidence they allege were destroyed or missing, including BH's phone extraction, all evidence of BH's second interview with law enforcement, and a mimicked crime scene image found on his Facebook. 6. There is no evidence the state extracted data from BH's phone. The only support the state ever possessed BH's phone is in the May 2nd, 2024 BH deposition. I want to know, why did this happen 11 days before the trial was supposed to start? Why didn't the defense interview BH before they accused him of being involved in the murders in the September 18, 2023 Frank's memorandum? The defense said BH indicated he was pretty sure he turned his phone over to police. Quote, I'm not going to say that positively, but I'm pretty sure they took my phone. They took my son's and my phone, end quote. The state believes BH is referring to February 17, 2017. When he and his son were both interviewed at the Delphi Police Department, BH said, quote, I'm pretty sure they did it right there in the lobby. I'm pretty sure they took both of our phones. Don't quote me on that because that was a long time ago, end quote. However, as documented in records previously provided in discovery, Indiana State Police collected BH's son's phone at Logansport High School on February 14, 2017 at 12:45 p.m. because his mother signed the consent to search form. BH was not present. An Indiana State Police sergeant met the son and his mother prior to the victims' bodies being recovered in hopes data on the phone may assist the police in locating the victims. The state is aware of no evidence the police extracted data from BH's phone or ever had possession of it. Therefore, there is no evidence that police destroyed or lost BH's phone extraction data, or evidence that data on BH's phone constituted potentially useful or exculpatory evidence for Rick. There is no physical evidence or witness statements that connect BH to the murders or crime scene. The defense is relying on pure speculation that data on BH's phone was potentially useful to exculpate Rick. Tom said, I think part of the defense's claim was law enforcement should have extracted BH's phone since he was a suspect that people tipped in as possibly being Bridge Guy. The defense said discovery included phone extractions of 101 people who were not suspects, but BH was a suspect according to some police officers. 7. In regards to a second interview of BH. In his deposition, BH believed maybe a year or 2 after his first interview, he was interviewed at the Logansport Police Department by 2 ISP officers. The state was unaware of any such interview. On May 28, 2024, an ISP detective said he and a female detective interviewed BH in the fall of 2017 at the Logansport Police Department. The detective stated he learned that BH had previously been interviewed and the investigation ruled him out as a suspect, so they met with BH to learn more about what he knew about Odinism. The interview was not recorded, nor was a formal report written. There is no support for the argument that evidence related to this interview was destroyed, lost, or exculpatory. Tom wondered, why is law enforcement having two officers interview someone, but they don't write a report to document it? Why did they want to know more about Odinism? 8. The defense claim a key piece of evidence is missing, an image from BH's social media that mimics the crime scene. However, the defense acknowledged the image is in their possession and showed it in depositions. The defense is arguing the charges should be dismissed based upon the destruction or loss of evidence the defense currently possesses. There is no case law supporting such an argument. 9. None of this evidence the defense says is missing or destroyed is exculpatory for Rick. BH is not a third-party suspect. There is no evidence that ties him to the murders. The evidence ties Richard Allen to the murders. 10. The state did not destroy or lose evidence purposely. The motion to dismiss is replete with unfounded allegations and distorted and misinterpreted facts. The defense make allegations that are not true and not supported by any evidence. A. The fact BH gave different answers to how many times he met Abby does not somehow make items A through H exculpatory. B. There is no evidence to support the rune on BH's hand mimics the sticks found on Abby. There is no evidence to support the facts outlined in the first Frank's motion. C. No portion of Rick's October 26, 2022 interview is missing. D. Holman did not lie. In his August 10, 2023 deposition, when he answered the question, was BH a suspect, with not really no, because the police encountered him through his son, who was a friend of the victims, and was interviewed, and the investigation revealed he was at work at the time of the murders. E. The state turned over the Todd Click letter, reports, and interviews after the state became aware they had not been provided. The state did not intentionally delay nor conceal any evidence. F. The state did not attempt to conceal the identity of the Purdue professor, nor does his testimony contradict the testimony of Holman. The professor said the defense mischaracterized his testimony. G. The state did not intentionally delay providing the extraction data from Libby's phone, nor conceal exculpatory evidence from it. H. The state did not conceal a report involving documented communication between Investigator Mullen and Trooper Blocker, nor is the info in the communication in any way exculpatory or useful. I. The defense's conclusion that 6.5 years after a complex criminal investigation began, officers had different recollections of what other officers believed during the investigation is somehow proof of a conspiracy to conceal officers' actual beliefs is very strange. The state does not know how that would ever be exculpatory or useful. J. Doolin testified he prepared a written report of his interview of Rick, but could not locate any evidence he recorded it. He prepared his written report very soon after his interview and would have had no reason to destroy the recording. K. The image the defense believe is a mimicked crime scene image is not missing. The defense is in possession of it. L. That BH is a key third-party suspect is false. There is no evidence tying BH to the crime. The defense cannot meet its burden to even allege that he is a third-party suspect. That was the end of that filing. The next filing was on June 18th. Accused response to this court's May 31st, 2024 order of judgment of the court and notice of conflict. It was 21 pages. Filed by the defense. There was a lot of information in this filing, so the summary is 18 slides. The overall summary is, the defense is still trying to get Gull to recuse herself. The defense didn't get off to a great start, spelling judgment two different ways in the first two sentences. Gull's May 31st refusal to disqualify herself in the case had several errors the defense wants to preserve for future courts, and to notify Gull that due to new information learned in her order, a conflict has been revealed which has caused Gull to become a witness. Tom's reaction: why has this case turned into a battle between the defense, prosecution, and judge, and not about facts related to whether or not Richard Allen was Bridge Guy and the killer? The defense does not wish for this pleading to delay future hearings, particularly related to transfer Rick to a jail. It is intended to provide correct information to Gull as she continues to self-evaluate her obligation to recuse herself, should she believe that bias or the appearance of bias exists. 1. A judge's obligation not to hear or decide matters in which disqualification is required applies regardless of whether a motion to disqualify is filed. I think this is their fourth filing to disqualify. The defense labeled this section with the heading, Judge Gull failed to inform the defense that Carroll County Sheriff's Office fabricated facts in a report filed in her court. According to a June 14th, 2023 report filed by the Carroll County Sheriff's Office, Gull advised the Carroll County Sheriff's Office it could ignore a defense subpoena for Westville inmate Robert Baston and refuse to transport him to the June 15th hearing on Rick's emergency motion to modify safekeeping order. Because of Gull's actions, the defense was without a key witness for the hearing. Tom said, "What about the actions of Baston, who has been complaining about Westville for a long time, but refused the opportunity to speak out at a major hearing covered by the media? When the time came to speak on public record, he refused to leave his cell and was ready to fight officers." It was anticipated Baston would testify as to the harsh, abusive, and unconstitutional treatment of Rick at Westville. The failure of the Carroll County Sheriff's Office to transport Baston left Rick without crucial evidence for the hearing. In her May 31st order, Gull claims she never advised the Carroll County Sheriff's Office to ignore the subpoena and leave Baston behind. Judge Gull's claim contradicts the Carroll County Sheriff's Office report this court received on June 20th, 2023, which stated, Tom's summary is, on June 14th, 2023, Deputy Wysocki was escorted to Baston. A corrections officer told him Baston refused to come out of his cell and said, "F you can't make me go." Which sounds like me when my parents used to tell me I had to go to church. So the corrections officer said they would remove Baston from his cell. Wysocki called the Carroll County jail commander who called Lesenby, who called Gull's office. Gull's office advised to leave Baston there if he did not want to go. Gull's order on May 31st stated, the decision by the deputy to leave without the witness was his and was not directed by the court. So was it someone on Gull's staff who said to leave Baston, or is there proof Gull was consulted and said to leave? What would Baston have said once on the stand? Would it be the same allegations from his 2 letters, or would he have refused, and it would have just been a waste of time transporting him? 11. Juxtaposed to the Carroll County Sheriff's Office report is Judge Gull's May 31st, 2024 order, in which she stated, the decision by the deputy to leave without the witness was his and was not directed by the court. 12. The first time that Richard Allen's counsel learned of these contradictory stories was in Judge Gull's May 31st, 2024 order of judgment of the court. I looked at prior filings, and on May 31st, 2024, Gull wrote on page 1, defendant claims the court directed the Carroll County Sheriff's Office to ignore a subpoena. The court directed an email to counsel on June 14th, 2023, regarding the witness refusing to cooperate with the service of the subpoena and demonstrating a willingness to fight the deputy attempting service. The court requested a report of the witness's refusal to cooperate and be transported for the scheduled hearing, and forwarded that report to counsel when it was received. The decision by the deputy to leave without the witness was his and was not directed by the court. On January 28, 2024, the defense filed an affidavit of Richard Allen. Page 14 stated, on the morning of June 15, 2023, Judge Frances Gull in chambers informed attorneys Rosie and Baldwin that she had released Carroll County from executing the subpoena on inmate Baston due to his resistance to being transported by Indiana Department of Corrections staff members. The defense misspelled Gull's first name, and they wonder why she says they're incompetent. The defense argued that Gull had this report since June 20th, 2023, but never notified the defense of the misrepresentation related to her involvement in the failure to transport Baston. At the very moment of learning that Carroll County Sheriff's Office filed a report with fabricated facts, she should have alerted the defense. Gull never reset the hearing, so the defense could provide the evidence Gull said was lacking when she denied Rick's emergency motion to vacate safekeeping order. The defense filed 4 Franks motions indicating law enforcement acted intentionally or in bad faith, plus 2 motions to dismiss based upon law enforcement's destruction of evidence. One of those motions was heard March 18, 2024, and Gull denied it. Gull was aware law enforcement fabricated facts in the June 14, 2023 report, thereby acting in bad faith, yet Gull never alerted the defense, and therefore law enforcement's bad faith was not made part of the record. Even if Gull would still claim that such a fabrication in a report would not have changed her ruling on the motion to dismiss, the defense was not able to include that info on the record for the Court of Appeals. Had Gull alerted the defense of Carroll County Sheriff's Office's fabricated statement, the defense could have used that as evidence of intentionality and bad faith on the part of Carroll County Sheriff's Office. By failing to provide this info, Gull prevented the defense from investigating this fabricated story. Gull's failure provides a rational inference of bias. I wonder if it could be possible Carroll County Sheriff's Office told the truth and didn't act in bad faith, and Gull didn't technically direct Wysocki to leave without Baston. Did Gull's staff receive the call and tell her that Baston was threatening to fight officers and should they force him to come? If Gull replied no, as a way of her agreeing Baston should not be brought against his will, amid his threat of violence, and was not Gull directing Officer Wysocki. The defense labeled this section with the heading, Judge Gull is now a witness in this matter as to Tobe Lesenby's credibility. Given that Gull is the only individual who knows she did not direct the Carroll County Sheriff's Office to leave Baston, she has become a witness to Lesenby's truthfulness and to the fact that the info contained in Carroll County Sheriff's Office's report is false. If Gull's story is correct, then she had a ringside seat to the intentional behavior of the Carroll County Sheriff's Office and or the bad faith of the Carroll County Sheriff's Office in that it, 1, intentionally ignored a defense subpoena for a defense witness and then, 2, fabricated a story in a police report claiming the judge authorized the Carroll County Sheriff's Office to ignore the defense subpoena. In this scenario, Gull is a witness. At future hearings and at trial, the defense should be able to cross-examine Lesenby on these contradictory stories. Tom said, "It was Baston's decision to refuse to help the defense and Rick, and there was no guarantee he would be truthful on the stand or provide testimony that Rick was being mistreated. Baston's letter said guards were calling Rick a kid killer and falsely telling him he had visitors, as well as several other inmates taunting Rick. But the defense didn't subpoena the guards or inmates to the June 15th hearing to tell their side of the story against Baston's claims. So how would Gull have ruled on anything Baston testified about? The defense must be able to call Gull to testify concerning the false statements in the Carroll County Sheriff's Office's June 14th, 2023 report. Baston would have testified about Rick's treatment at Westville, which directly led to the deterioration of his mental state, and false statements concerning his involvement in the crime. Tom wants to know, why is Baston a witness to Rick's abuse, but Rick won't get on the stand to explain the abuse he suffered? The Frank's Memo No. 1 said on May 4th, 2023, Rick told Baldwin and Rosie they were going to kill him. By they, he meant the guys with the Odin patches, but there was no mention of abuse other than Rick being tased for refusing to remove his hands from outside his cell after he was warned of the consequences for not following the rules, and one other possible tasing without supporting evidence. Rick called his wife April 3rd, 2023, and said he killed Abby and Libby. The defense said Rick's mental health had been normal for the first 5 months from early November 2022 to April 3rd, 2023, but now they are saying Baston would testify that Rick's abuse at Westville led to the deterioration of his mental health, which caused him to confess. Rick's prison cell is under 24-hour video surveillance. Where is the evidence of this abuse other than the 2 tasing incidents? On April 11th, 2024, the defense filed a memorandum of law in support of defendant Allen's motion to suppress, which stated Baldwin and Rosie learned Rick has been accused of making incriminating statements to inmates and guards, nearly all of which occurred between mid-March to June of 2023. There are medical and psychiatric records suggesting Rick was in a state of psychosis. So, was Rick being abused by guards, and that is why he called his wife, or because he was in a state of psychosis? The defense seems to change the reason based on what they're trying to prove. Or was Rick confessing because he was telling the truth? The defense plans on issuing subpoenas and calling Gull to the stand at future hearings and at trial to testify that she never directed Carroll County Sheriff's Office to ignore a subpoena or to leave Baston behind if he did not want to attend the June 15th, 2024 hearing. The defense made an error. This should be 2023, not 2024. Also, what does Baston not testifying about Rick's treatment at Westville have anything to do with Rick's trial, with evidence about where he was at 2:13 p.m. on the day of the murders? The defense says Gull should recuse herself as she is now a witness. The defense labeled this section with the heading, Judge Gull's failure to admonish the Carroll County Sheriff's Office may cause law enforcement to believe that they can create fabricated stories in this case with no consequences. Despite having the Carroll County Sheriff's Office report since June 20th, 2023, Gull has failed to admonish the Carroll County Sheriff's Office for filing a report that contains such a flagrant falsehood, and which is arguably an attempt to cover up their illegal actions in ignoring a subpoena. Gull's failure to address that provides a basis for state's witnesses to believe they can freely fabricate stories which subvert justice for Rashad Allen without consequence. This provides a rational inference of bias. Both McClelland and the defense haven't noticed they spelled Richard as Rashad in various filings. I want to know who is proofreading these documents, because it doesn't seem like anybody is. A few weeks ago, I emailed both the prosecution and defense offering free proofreading services. Neither of them got back to me. I don't think they were busy proofreading. The defense labeled this section with the heading, Judge Gull continues to errantly accuse the defense of improperly filing ex parte documents. Gull said the defense is to blame for ex parte pleadings that were accessible to the prosecution. On March 7, 2024, Rosie alerted Gull about his grave concerns about McClelland receiving the ex parte documents. 13 days later, on March 20th, 2024, Gull replied, I would encourage you to educate your staff on how to properly file pleadings. Exhibit A showed the DocsPop filing process of the February 26, 2024 ex parte document that court staff mishandled. Footnote 2 stated, Gull seems to believe parties can only file through the Odyssey platform, but they can also through DocsPop, which the defense used February 26, 2024. The defense has used both Odyssey and DocsPop. The tutorial Gull sent details the Odyssey platform, not DocsPop. Upon receiving this February 26, 2024 pleading, court staff would see at the top, ex parte pleading to be placed under seal, which should have alerted court staff it was ex parte, causing them to follow proper procedures. The staff for the defense filed the ex parte documents correctly. The DocsPop printout shows the only service contacts listed on this ex parte filing were Baldwin and Rosie, not McClelland, James Luttrell, or Stacy Diener. Furthermore, the printout shows that all documents were marked as confidential. Tom points out that the defense continues to misspell the other attorneys' names. Luttrell has 2 U's and no E. They spelled Stacy's name correct here, but on the last page they spelled it wrong. Good luck, Rashad. After the defense correctly filed the ex parte motion, court staff erred in how it processed the document, causing McClelland to have access. It seems likely the reason for no further ex parte issues was court staff learned the proper manner to process ex parte documents. The document Gull refers to does not assist the practicing lawyer in filing ex parte documents, as it is a tutorial for court staff. Exhibit B includes the tutorial Gull sent the defense. The defense labeled this section with the heading, Judge Gull has failed to admonish Prosecutor McClelland for improperly reading ex parte pleadings while continuing to denigrate defense counsel. They noted that on March 6, 2024, a prosecution filing directly quoted from the defense's ex parte filing. Exhibit C shows Rosie emailed Gull and McClelland about how an ex parte motion was made accessible to the prosecution. On March 7, 2024, McClelland admitted he also had access to 3 other ex parte filings. Footnote 4 stated, the defense believes McClelland reviewed only 2 ex parte filings, as 2 of the filings he referenced are not ex parte. McClelland chose to read those ex parte documents rather than promptly deleting them and alerting the defense as required under Indiana Rule of Professional Conduct 4.4b, which states, a lawyer who receives a document relating to the representation of the lawyer's client and knows or reasonably should know that the document was inadvertently sent shall promptly notify the sender. I agree that any lawyer who does that should be reprimanded. McClelland, reading from defense's ex parte documents, provided the prosecution with an improper glimpse into the manner in which Rick's attorneys would be defending him. This is another example of a subversion of Rick's due process rights. Gull failed to reprimand McClelland, nor refer him to the Office of Judicial and Attorney Regulation for ethical misconduct. Gull said on April 30th, 2024, she was referring defense counsel to the Office of Judicial and Attorney Regulation concerning a short and bland press release. Gull is clearly treating the prosecution differently than defense counsel, and this provides a rational inference of bias. The defense labeled this section, This court offered its hand-picked public defenders an opportunity for a hearing on the Franks motion, but denied the same opportunity for Baldwin and Rosie. It seems like the defense didn't proofread again. They said picked, which reminded me of that Purdue chicken commercial where they're like... The defense already made this point in the January 28th affidavit of Richard Allen. In her May 31st, 2024, order denying the defense's request for disqualification, Gull said she has no bias against Baldwin and Rosie. The defense complained Gull didn't rule on the first Franks request between September 2023 through January 22, 2024, when she denied it 4 days after Baldwin and Rosie were reinstated, but Gull told the two temporary public defenders, if defendants' new counsel inform the court they intend to pursue the Franks motion, the court will schedule a hearing which demonstrates she is punishing Rick due to her bias against Baldwin and Rosie. Tom said, didn't Judge Gull also hand-pick Baldwin and Rosie? Oh. The defense labeled this section with the heading, in its order, this court claimed that it is irrational and unreasonable for the defense to assert that as lawyers with 70 years of combined experience, they have never had a judge provide a hard-end date for a trial. Calling defense counsel irrational and unreasonable shows bias, especially when the court is wrong in its understanding of Jury Rule 4. At the May 7, 2024 pre-trial hearing, Gull stated, quote, Jury Rule 4 requires that I issue summonses to the jury with the dates of the trial, end quote. The defense argued, Jury Rule 4 does not discuss the length or dates of the trial or require courts to place a hard-end date. Jury Rule 4 is primarily referring to the time span citizens need to be on the alert they could be summoned for jury duty. Jury Rule 9, term of jury service, places no limit to the length of actual trial. Gull's errant interpretation of jury rules forced Rick to seek a continuance of his speedy trial to assure he could thoroughly present his defense without time restrictions. This only negatively affected the defendant and his constitutional rights, not the prosecution, and thus provides a rational inference of bias against the defense and Rick. Tom thinks the defense should have moved ahead with the hearing on third-party perpetrators to know if they would even be allowed to present alternate suspects and need their requested 15 days for the defense, which would have maybe prevented their client from being in custody for 5 additional months. Also, as Gull pointed out, she approved the speedy trial and set the May 13th through 31st dates on March 7th, but the defense didn't question the length for over 7 weeks until 2 weeks before the start of the trial. Of the approximately 185 witnesses identified by the parties, a dozen or more are expert witnesses whose testimony will generally take longer than fact witnesses. Gull refused to place a limit on the time allotted to the prosecution, but absolutely limited the time for the trial, thereby limiting Rick's time to present his defense. The hard limit on the end of the trial denies Rick his Sixth Amendment right to confront witnesses, his Sixth Amendment right to the compulsory process for witnesses, and his 14th Amendment due process right to present a defense. Gull's maligning of defense counsel as irrational and unreasonable, when in fact it was Gull that was wrong about jury rules, and her claim that courts statewide provide a hard-end date to a trial, offers a rational inference of bias against the defense. The defense labeled this section with the heading Judge Gull's May 31st, 2024, explanation for her denial of defense motions without a hearing provides a rational inference of bias. Gull stated, if pleadings on their face are not supported by the law or admissible evidence, judicial economy does not require a hearing. The defense stated, Gull knows very little about this case. How could Gull determine what evidence would be admissible until a hearing takes place and the defense moves to admit the evidence? Gull's claim that defense evidence is inadmissible before conducting a hearing and listening to the defense's contextualization of the evidence provides a rational inference of bias. In the future, if Gull denies defense motions based upon her belief the defense pleading is not supported by the law or admissible evidence, the defense requests she identify the evidence she believes is inadmissible and explain why it is inadmissible. Also, instead of simply stating denied without hearing, the defense will request she explain why the pleading is not supported by the law. The defense labeled this section with the heading, even concerning something as basic as a request for a recess, Judge Gull shows favoritism to the prosecution. In her May 31st, 2024 order, Gull stated she does not show favoritism to the prosecution. However, Gull has shown her differential treatment between the prosecution and defense in a variety of ways. Because cameras have not been allowed, it is difficult to hear Gull's angry tone when addressing the defense versus the prosecution, and also to visualize her disdainful facial expressions she makes toward the defense versus the prosecution. Tom thinks Rick deserves a fair trial, but complaining about recess requests is so childish and so far away from the facts that matter to determine whether or not Rick was involved in the murders. In footnote 7, the defense said that in the future, the defense will likely request cameras for all hearings and trial. At the June 15, 2023 hearing, McClelland requested a recess to use the restroom, and despite Rosie saying he didn't need to break for lunch, Gull said they would break for lunch. Gull asked McClelland, No, that's all right. How long do you think you'll be? McClelland said, downstairs and right back up. Gull replied, No, I mean in your witnesses with your evidence. McClelland said, Oh. Gull replied, Ding dong, I don't care how long it takes you to go there. No, I don't care about that. At the May 7, 2024 hearing, the defense sought a short recess to confer with Rick concerning continuing his speedy trial. Gull asked why. Rosie said he wanted to privately discuss with Baldwin the scheduling issues, so Gull granted it. The defense continued, quote, Judge Gull did not playfully call Brad Rosie ding dong, end quote, but instead questioned Rosie's reasons for seeking a recess. Then, Judge Gull surprisingly asked the prosecutor if he had an objection to seeking a 5-minute recess. This is odd. After McClelland asked for his recess, Gull asked Rosie if he wanted a lunch break. I don't see how asking both Rosie and McClelland their thoughts on a break request showed any difference or bias. The defense is spending their time researching how Gull reacted to prior recess requests. What are they doing to prepare to cross-examine witnesses at the trial? What evidence are they going to present to a jury to have reasonable doubt Rick was not involved? How will they argue against facts that point to Rick lying? How will they explain Rick's incriminating statements to almost 30 people? How will they explain if there was never a group of 3 girls near the start of the trail at noon when Rick said he passed 3 girls? Have they finished their preparation for all of that? Because this seems like a waste of time and Carroll County taxpayers' money to be complaining about ding-dongs. This court failed to address the appearance of bias which exists in this case. Gull must consider both actual bias and the appearance of bias when determining whether to disqualify herself. It is the appearance of bias against the defense about which the public has written the Indiana Supreme Court. And it is the appearance of bias, the existence of which Gull should recognize and for which Gull should voluntarily recuse herself. Failure to address other issues contained in the first motion to disqualify. Gull addressed a few other defense issues contained in their second motion to disqualify. However, in the May 31st order, Gull failed to address all issues in the first motion. The defense requests Gull to review the first and second motion to disqualify and consider whether she feels obligated to disqualify herself from this case based upon the itemized reasons contained in those motions as well as in this response. Tom says she's obviously not going to remove herself. Stop wasting your and your client's time. That's how excited I sound with 3 exclamation points. This is the final slide. Conclusion. The defense wishes to move forward and have Gull conduct hearings. Most immediately, the request to have Rick moved to either Cass or Tippecanoe County Jail. This motion is intended to respond to Gull's order for purposes of preserving the issues for the record and so that Gull may consider whether or not she feels obligated to recuse herself, which remains an ongoing obligation, whether or not the defense is seeking her recusal. On June 21st, Judge Gull issued a 1-page order rescheduling the hearings, which were supposed to be May 21st to 23rd, to July 30th, July 31st, and August 1st, starting at 10 a.m. in the Carroll Circuit Court in Delphi. Below is a list of all the items they're going to discuss, but on the next 3 slides, I'm going to summarize which each one is about. Numbers 1 and 2 essentially are the defendant's motion to suppress and the state's response. So Baldwin and Rosie want to suppress everything Rick said and wrote in prison. Baldwin and Rosie want to suppress all statements from Rick's October 26, 2022 interrogation by Jerry Holman because Holman failed to read Rick his Miranda rights. McClelland's response was, Rick voluntarily said incriminating things to almost 30 people, and his Miranda rights were not violated. The next issue is the state's motion for admissibility. At the trial, Nick McClelland wants to present Rick's incriminating statements he made to a psychologist at Westville. Number 4, defendant's motion to compel and motion for sanctions. The defense said McClelland has been late and disorganized with evidence which has hindered the defense in preparation for trial. Their list of requested sanctions include: court may prohibit McClelland from introducing designated matters in evidence. Defense needs the 2019 Google geofence warrant, standard operating procedures for 3 agencies, chain of custody related to bullet, sticks, branches, and bark. Also, the law enforcement presentation on the Odinist EF. The FBI Behavioral Analysis Unit and law enforcement reports assessing the crime scene regarding Odinism, Nordic culture, etc. They want Gull to instruct the jury that McClelland received Todd Click's exculpatory letter but failed to turn it over to the defense for over 4 months. Permit defense to play any video that was belatedly produced without objection from McClelland. Prevent the prosecution from rebutting the evidence that Todd Click provided. All data from Libby's phone, including video from all data extractions, be excluded from evidence, which is surprising to a lot of people that the defense says Richard Allen is not Bridge Guy, yet they don't want that to be evidence shown to the jury. McClelland replied that he gave everything to the defense and did not make a determination of what was discovery and what was not. The defense has been lazy and should have made greater effort to locate documents before filing the motion to compel. A lot of what the defense wants won't be used at the trial and is not exculpatory for Rick. The defense already had all the requested information except the chain of custody and standard operating procedure documents. 5. Defendant's motion to vacate safekeeping order. The defense wants to transfer Rick from a prison to a jail. 6. State's motion in limine and the defense's response. McClelland requested Gull require Baldwin and Rosie to refrain from mentioning a variety of things during the trial, including anything about Nick McClelland, witnesses, third-party perpetrators, Odinism, cult or ritualistic killing, Odinists, Kegan Kline and his dad, or Ron Logan, Todd Click, geofencing that is not relevant, prior bad acts of witnesses, how the files handed over to the defense were labeled, and PowerPoints that were executive briefs provided to law enforcement. The defense replied, they plan to call more than 20 witnesses who will provide credible information regarding the culpability of third-party perpetrators. The state's request is also overly broad and therefore should be denied. The final issue, number 7, defendant's second motion to dismiss and the state's response. Since their first motion to dismiss, the defense learned of other exculpatory or useful evidence the prosecution has not turned over, is missing, or the state destroyed that relates to third-party suspect BH. McClelland also failed to turn over Libby's phone data for nearly 9 months, and there is no audio recording of the Dan Doolin conservation officer with Rick from 2017. McClelland replied, there is no exculpatory evidence the state has not turned over. BH is not a third-party suspect, and there is no evidence tying him to the murders.